Yes, Mr. Pasha. Yes, Mr. Farasat.
I appear for writ petition 59 because we are the only political party before your lordships. And my lords, despite being a ruling party, my lords, we have taken a principled stance not to accept.
May I be excused for that?
Yes, Mr.
Not to, my lords, accept any electoral bonds, and we have not taken a single rupee of electoral bonds in the last 5.5 years. At, if I may say so, my lords, at much cost to us. My lords, there are 3 submissions, my lords, I'll try to make very quickly. Plus, first,
That report of the ADR, it says that your party has got some electoral bonds also.
no, Malaz, that's because they gave us this thing. We have just given the detail because they asked when your lordship's order, when the order was passed that every party has to disclose details. So we would have just responded saying that we have not taken any electoral bonds. There's no question of taking any. This is a principal stance. We have not taken any. Plus, the first submission I intend to make was 3 submissions. Because the first submission is that the architecture and effect of the electoral bond scheme is not to reduce black money, but to reroute non-anonymous banking channel funding to anonymous electoral bond.
Please repeat.
Plus, the architecture and effect of the electoral bond scheme is not to reduce black money funding, but to reroute the non-anonymous banking channel. Well, that is the conventional banking channel available.
Architecture and effect is not to
reduce black money funding of political parties, but to reroute the non-anonymous banking channel funding.
But to reroute
the non-anonymous banking channel funding to anonymous electoral bonds.
To reroute
non-anonymous banking channel funding to anonymous electoral bonds. Well, that's the first submission. The second is that the legally ordained informational black hole, which this creates, the electoral bonds scheme creates. It's a legally directed information black hole, goes against the concept of informed electorate under 19(1)(a), read with my lords, Article 326 of the Constitution, both. So it goes against the principle which is constitutionally mandated of an informed electorate under Article 19(1)(a), read with Article 326. And the third submission for your lordship's consideration is that it violates the right to conscience under Article 25 of individual shareholders, because they don't know where their money is, what their money is being used for. I'll try to make that.
Mr. Sibal also argued.
Mr. Sibal argued, but he didn't pitch it on right to conscience under 25. Because I'm specifically saying it violates right to conscience under Article 25.
Actually, the 19(1)(g), right, you can say.
But also, I'll try to make it good, because I know it's not the usual argument to be made, but I'll try and make it good. Because on the first, before I begin with those submissions, just one aspect is this matter is essentially about 2 things, democracy and disclosure. Those are the 2 fundamentals, in my respectful submission, which guide the underlying issues which arise in this matter. This matter is not about contribution limit, except on that 7.5% issue, or expenditure limit, or expenditure timeline, which is when can the parties spend before election, after election. Those are all aspects which are litigated not just in our jurisdiction but across the world. This is about something which pervades all those aspects, which is disclosure. Every aspect it pervades, which is disclosure, and disclosure not just to authorities. There are 2 kinds of disclosures. One is I should only disclose to the Election Commission. That may not be sufficient. This is about disclosure to the authorities and to the public at large. And that is where the rights under 19(1)(a), 326 come into play. Because insofar as why this is relevant from a perspective of democracy. Plus the principle of one man, one vote, it's not just about that I cast my vote. What is the substantive value of that vote? Because it basically entitles me to claim equal representation to my representative, equal influence over the democratic process, and to show that my views have equal worth in the system. This scheme, my lords, possibly changes that by shifting the center of gravity from the elected public to somewhere else of the political discourse and influence without the public even getting to know about it. Because with that, I will enter the first submission, which is the architecture. Because what does this scheme do? Because this scheme effectively is an alternative white money channel which the government has created. There was already a disclosure-based channel, the normal banking channel, the RTGS, the bank draft, the check, which was available. So this is a new white money channel. What they have added is anonymity to it. By definition, therefore, it cannot be including money which would otherwise be black money. It can only deal with money which will anyways be white money, which a person can disclose as white money. Plus the function of whether a money is disclosed to a banking channel and therefore declared as white is not a function of what it will be eventually used for, whether to donate to a political party or something else. It's primarily a function, I don't say exclusively, primarily a function of two things. First, whether the money is legally obtained. If it's illegal money, I can't disclose it to a banking system normally, unless I'm trying to launder the money. And second, if I'm trying to suppress my income is X and I'm trying to show Y to save tax. Plus, this will not bring in any of that money which is anywhere in the black space, in the cash economy. So what does this do? By definition, what this will do is the existing white money which is in the system, which was being donated to political parties through the non-anonymous fully declared route, it will shift that to anonymous electoral bonds. That's more or less the scheme of the architecture of the electoral bond scheme itself. And my lords, that is borne out by data as well. Now, your lordships will I'll try to bring my lords to the data straight away. First, my lords, in terms of what is the cash usage in the economy. Because of course, cash usage, there can't be a perfect number that this is the cash usage in electoral system. We always have to go by surrogates, some surrogate. So my lords, in that context, I'll compare the 2014 Election Commission recoveries of cash during election, the 2014 general election, and 2019. The amounts of cash recovered in 2014 have gone up by 3 times in 2019, which by itself is indicative. If the commission is catching more money, that means there's more money in circulation. A large chunk of it will be belonging to political parties. So your lordships will first have volume 4, my lords will have page 1825. This is, my lords, the 2019. I'm only relying on Election Commission data for my submissions, no outside data, my lords. Page 1825. This is all the recoveries they made in the 2019 election. Your lordships will have page 1826. At the bottom, grand total.
Second column is liquor.
At the bottom allows a grand total on page 1826. Well, it says cash 844. Your lordships have that?
Largest is Andhra and Tamil Nadu.
To the extent that cash is used in the elections, maybe this will show that.
So, my lords,
That's a limited extent.
I agree. I'm grateful to my lords.
We ought not burn that.
So, my lords, my point is that cash can only increase. Cash cannot be controlled by definition by this scheme. Because this scheme, let's assume, my lords, the cash was tomorrow even banned, for instance, by political party. Cash can still be used by political party. That's a reality, unless the cash economy itself ceases to exist. So this scheme, because I am trying to meet the argument which is in support of the scheme by the union right since the beginning, including in their affidavits, that we are trying to transfer what is there in the cash economy into this. My submission is that is just not possible given the nature of this scheme. In fact, it's not possible unless even if you bar prohibition, even if you prohibit it, you possibly can't do it unless the cash economy itself ceases to operate, independent of political parties. So, Mullah, that is really a red herring argument is my submission for your lordship's consideration.
The argument of the other side on that is they're trying to experiment. If it is possible, they can do it. If they can wean away from the cash.
So, Mullah,
That may not really cut.
you'll-
We can't say that the attempt should not be made or experimentation should not be made.
so, Mullah, but what if it were to primarily impact the other side which was already being disclosed? So what's happening now is you have two channels, anonymous cash channel and anonymous banking channel. So what the white and the black channel are anonymous now. My submission for lordship submission consideration is this. There was earlier a black channel, the cash channel which was there, which needn't be disclosed, etc. Now you have created an anonymous white channel. So both are anonymous. And this is at the cost of only one thing, which is disclosed white channel. Well, I'll try to make that good. I'll try to, even through data, I'll try to make that good because we have the benefit of 5 years of operation of this scheme. Well, that's the benefit we have. So what's the impact of it? Parties which were getting 70 to 75% of their political disclosed contributions from check, bank, RTGS, that's the disclosed white channels, are now getting 20%, 15%. The electoral anonymous scheme has taken over at the cost of white channel. So my submission for your lordship consideration is this. It's not to attack the black money. It's actually to attack the white disclosed channel. And that's the actual impact as well of the scheme. And Mullah, I'll just place the data and then Mullah, I'll go to my next point. What we have done, we did an exercise. What we have done, Mullah, 29 seats, every party gives a contribution report. Above 20,000. Above 20,000 they're required to. Well, we collated the last 10 years from 2013 onwards, all the reports. And Mullah, your lordships will have page 5542, just for a moment, just at volume 4.
542.
5542. 5,542. Volume 4. Plus at 5543, this is formulas two parties, the two national parties I have collated. Well, the data is for all of them, but when I show the bar graph, that is for two parties, and I'll tell you lordships what we have done. 5543, your lordships will have. Lords have that.
These are list of donors who give.
That's right. So from each of the list, we have taken all the list of donors, and it says against that, for instance, it says check number, DD, etc. Correct? My lords will have the first cash entry in this one is at 5553.
That's less than 2,000.
No, it's more than 20,000. Plus more than 20,000, you have to disclose whether cash or check. Either way, you have to disclose. That's the statutory requirement. 5553. Look at 153, serial number 153 in that chart. Some Mr. VV, 1 lakh cash. My lords have that? Page 5553.
Yes.
VV.
So, Mullah, what I have done, Mullah, each entry we have added up for two largest political parties for 2 years to get the numbers, because there was no other way to do it. This is not information available in the public domain. This was the only way to do it. So we have added up each of the entries to determine what is the check amount which they were getting as a percentage of their funding in 2013-14 and what they're getting post-electoral bonds. And Mullah, the net result of that, Mullah, I've prepared a chart for your lordship's consideration. The learned courtmaster will kindly screen share that document which has been emailed. Yes, give a copy to the learned solicitor.
Airdrop.
Plus, your lordships will have it on your screens now. Plus, just if the learned court master can bring it down a little, just. Yes. Correct. Yes. So, Manoj, my respectful submission is now the entire political funding substantially is anonymous. Because black channel continues. Manoj, at the cost, if the Manoj, if the objective is to have some kind of disclosure, at the cost of disclosed white money, if you are increasing non-disclosed white money, Manoj, that's what the real, your lordships will have this chart, page 1. If the court master can just bring it down a little.
There's a little flaw because of the bearer bonds as such are bearer bonds that's going to that's creating a problem. That's all. We have understood that argument.
And Manoj, I'm making the argument solely to meet the union's justification of the scheme, which is that it's meant to bring in black money into the white system. My respectful submission to meet that is, it actually does the opposite. It takes away the non-anonymous white money and puts it in the anonymous kitty. That's my submission.
That we already have.
That's right. So, Manoj, I am saying, therefore, to that extent, A, the justification is not valid, and B, for that reason, it's arbitrary as well. It doesn't meet even the stated justification.
Already argued for basis even.
Because the determining principle, because one of the tests of arbitrariness your lordships have stated is, it is absent a determining principle. Because here the stated determining principle is contrary to what the scheme actually does and intends to do.
What it basically, according to you, does is that it brings into the fold. Earlier, what you had non-anonymized white money.
That's right.
Now that is replaced increasingly by anonymized white money.
And that's the real victim or target of this scheme, not the black money. That's my respectful submission. Because black money will continue irrespective. That funding will keep on continuing. So now the two channels, both are anonymized, white and black. That's my respectful submission. That's the scheme. That's the real picture which this scheme does to our political financing, Manoj. That's what it does.
All right.
Yes. Plus,
Anything else now, Mr. Farasat?
plus just two short submissions, I will not labor them. Plus the second point is your lordships will consider that under Article 326, Manoj, there is guaranteed adult franchise. There's some debate on whether it's a right to vote or not, because the right to vote actually specifically vis-a-vis an individual voter flows from Section 62 of the Representations of People Act. But Manoj, it is definitely, it defines what an electorate is. 326 at a minimum defines what an electorate is. My lords, will just have 326 for a moment. The elections to the House of the People and to the Legislative Assembly of every state shall be on the basis of adult suffrage, that is to say, every person who is a citizen of India and who is not less than 18 years of age on such date as may be fixed in that behalf by or under any law made by appropriate legislature and is not otherwise disqualified under this constitution or any law made by appropriate legislature on the ground of non-residence, unsoundness of mind, crime or corrupt or illegal practice, shall be entitled to be registered as a voter. So this is a creation of an electoral list. You are entitled to be registered as a voter. So this gives you what is the electorate. It may not give you a final right to vote because that will still be regulated by the statute in terms permitted by 326 itself. So I don't want to get into that debate. Recently, there are differing views of this court itself. Because recently in the Election Commission appointment court, a 5-judge bench of this court has taken the view that although it is a statutory right. They're not giving a definitive finding because the earlier 5-judge bench had said that it is only a statutory right. So, Mulaz, I don't want to get into that debate. Even assuming this is not a right, it is at least defines the electorate. And this, when read with 19(1)(a), it envisages, in my respectful submission, an informed electorate. So when your lordships will nest the right to information, my submission before your lordships is nest it not just in 19(1)(a), but also nest it in the informed electorate under 326. And what's final submission, the third and final submission? Plus, it impacts two kinds of democracy, this scheme. One is popular democracy and the other is shareholder democracy. The only people who are part of we, the people in the company, is the shareholders. They also vote. That is the natural shareholders. They are the only ones who are excluded from knowledge of where the money is going.
Already argued by Mr. Sitla.
But just on one aspect, on that, I quite see that. Another shareholder, a share is a property of a shareholder. My property's usufruct is being used to fund a certain purpose. Well, this is in my written submission. I won't take your lordships to it. But political views have also been recognized by this honorable court as part of right to conscience. I don't even know who my money is being used to fund for. A person with A conscience may not like a right-wing party. A person with B conscience may not like a left-wing party. It may infringe on his conscience to support his property to fund that party. So at least I should have a right to exit. I can't certainly manage the company being a single shareholder, but I should have a right to informed exit. I'm even denied that by blackholing the information from me. So in that sense, it actually violates the Article 25 right of a shareholder. I'm grateful for that.
Thank you, Mr. Farasat.